My name is Cami Heiza, and I am the founder of the Social Media Breakfast of Houston, and my Twitter name is CamiChat, Kamichat, and you can find me pretty much everywhere under that name. I am really excited and pleased that I have a great guest that we've been trying to actually get as a guest, I don't know, since we were at a different location. I mean, we've been working on this for a long time. Anyway, Travis is here with me. And Travis is a really great lawyer who gets paid, I don't know, $400 or $500 an hour. So you guys can bring out the tip jar and help me pay for his hand afterwards. But anyway, he agreed to come today, not to be your lawyer. So he's not going to give you any legal advice today that you should take without talking to your own personal lawyer. And
it's general informational purposes only.
Okay.
That's the caveat. That's the legal.
Oh, I've got to say it right. General information purposes only. My insurance doesn't cover you suing me over him giving you advice. That's some work. Anyway, so he is a former journalist, so he comes from a communications background, really, and he understands that kind of world. He has been practicing law with Gray, Reed, and McGraw for 16 years. Long time. He's been there a while now. Gosh. His practice focuses on technology, marketing, and media. And in addition to practicing law, he's the co-owner of consumer legal businesses, Swiftlings.com, which by the way, I'm going to ask you about. How do you say these?
It's Swift Filings.
Swift Filings.
Swiftlings is a whole nother business, but I like that idea. Maybe we can start that.
Swift Filings, and you can tell us about these in a minute. I'll ask you about these in our conversation. Trademarketing.com and Legal Vorce.
It's Trademark Engine and Legal Vorce.
Can't do it, guys. I'm sorry.
Somebody bring her another pen and coffee.
New contacts. Anyway, so he has several different online businesses, and so he understands going online and trying to figure out how to promote yourself online. He also has a really well-known blog that many people follow all across the country, a legal blog. So I'm very excited that you're here. Thanks. Awesome. So I want to just start with general. And we're going to leave some time at the end, by the way, for, and this is really loud, isn't it? There we go. Just find it. I'm going to leave a little time at the end for your guys' questions, because you may have things in your own business that you're concerned about. But some of the things that we came up with were maybe starting with some current events. So there's been a lot of talk about fake news. So what are our legal requirements as content providers to provide true information and know that it's true? Because I mean, we're sharing links all day. How do we? I mean, am I going to get in trouble if I retweet fake news and get sued for it?
So the legal answer is probably not, but the moral answer is you're going to go to the deepest depths of hell for spreading fake news. On the legal side, obviously, if you are marketing on behalf of a company and you spread something that it's usually the Federal Trade Commission is the national entity that would track this, or the State Attorney General's office here in Texas. If you're spreading something that is false and deceptive in the context of marketing, then certainly you can get in trouble. If you're spreading that, Hillary Clinton likes to eat children or something ridiculous like that, that's when you're going to hell. But you won't most likely you're not going to get in legal trouble. The only legal issue that might pop up there is if it's defamation, and Hillary's not going to sue me or you. But if it's on a much smaller scale, if you're spreading something else,
competitor, let's say.
Yeah, if you're spreading something about a competitor, or just a rival, take it out of the political realm, but for whatever reason there's personal grudges, you start spreading those things, you start getting into the defamation, libel, slander type of things. And so if you state something that is false, that could hurt somebody or harm somebody's reputation, then you can get in trouble. And libel law recognizes the concept of republication. So even if you're not the original person who made some false story up about somebody, if you share it, including links and reposts and all these other things that we can do with a couple clicks of a mouse, you can be liable too. Obviously, the person who first did it is sort of the number one target, but you can get there is legal liability for republication, is the term of art, of libelous material.
And I know that in my business, I certainly have to carry insurance that covers me for inadvertent, of these kinds of things. So what do you suggest that people do? Carry insurance if they have a small business, or if they're just a blogger, like what do you suggest?
So this gets into an interesting area, and a lot of times your homeowner's policy will cover if you get sued for defamation and somebody says from your house you reposted something online, your insurance carrier, your homeowner's coverage will a lot of times cover it. For a small business, it's usually covered by general commercial liability policy, just a kind of a general one. The issue is that libel and slander are considered in what we call intentional torts. So there's the oops, I screwed up and I hit somebody in my car. That's negligence. Then there's the intentional tort. I punched you in the face, right? I'm not going to do that this morning. But
I thought I was going to hell.
Yes, yeah. No, you're already going to hell for spreading fake news. So, but that's considered an intentional tort. So it's somebody purposely spreading something they knew was false or should have known that it was false. And so sometimes that can come out that won't necessarily be covered because the purpose of the business is not to commit an intentional tort. Just like your business may not cover you if you punched a customer because, your insurance may not cover you. If it's an employee, you may not be liable for the employee's conduct if it's something so outside the bounds of what they're supposed to be doing. And so it gets to be a gray area, but for the most part, your GCL, your general commercial liability policies will cover these types of torts. And even if you do some type of marketing that you thought at the time was right or accurate and you kind of push the boundaries a little bit, it will usually cover that as well.
Yeah, and it's funny because I did just get a letter from my insurance company for a $1 million umbrella policy that would cover stuff like that. So it's interesting you said that because I already have it through Hiscox is what I use, an online service. But so very interesting. So having insurance, which is not what we were going to talk about today, it's kind of important, it sounds like. So how do you, we're talking about fake news, but now let's talk a little bit about people's stuff, so I'm taking photos right now, video, we're streaming online. How do we protect our intellectual property, and do we need to worry about how do we let people know that it is our property?
So we'll start kind of with the basic. There's really two intellectual property rights that apply to putting things online. It's trademarks and copyrights. We'll start with copyrights because it's a little bit easier. Copyrights applies, you don't have to do anything. As soon as you create something and you put it out there for somebody else to see, you own the copyright to that material, assuming it is relatively unique. So you don't really have to do anything to claim your ownership to it. And you don't have to register it. You can put the little circle with the C if you want to look formal and official in 2017. The reason people register copyrights is in order to sue for an infringement, you have to have it registered. And it can get a little nuanced, but there's some timing issues involved that if you want to recover statutory damages and attorney's fees in a lawsuit, you have to file it pretty quickly. And that's why most publishing houses and the people who have the money will register their copyrights. Because imagine if if I did a 1-minute video and somebody stole my blog post. That's easier. So somebody steals my blog post word for word, and they put it on as their own. They've infringed on my copyright. Well, how do I prove damages? If I don't register the copyright with my blog post with the U.S. Copyright Office, I have to prove actual damages. And so I have to somehow prove that by taking my blog post, which, I think is pretty good, but I don't know how to really monetize. I can't really point to, because you took that blog post, I lost X amount of dollars. I lost these sales. I don't license out my blog post to anybody else. There's not really a licensing value on that blog post. So that's why people do go forward with registering it so that they don't have to prove that. If it's registered, the law says I'm entitled to, I think it's between $750 and it's either $30,000 or $50,000 per copyright infringement. So then if I sued, I just have to say there was a copyright infringement, and if it's that scale depends on how bad, how malicious, how bad was the actor. I can go to court and say, give me $50,000 because they intentionally, willfully, maliciously took my stuff, and I don't have to prove damages. So that's why people go through the hassle of registering copyrights.
No, that's good. So mostly, I think people, if you have something, if you say somebody did steal your blog post and you haven't registered copyright, because most of us don't do that, but if you have a big company, maybe you should be. What do you do then? Like if you see something on somebody's site that's yours that got scraped and put there, like what do you do?
So there's a sort of a poor man's enforcement online. So in my world, for 90% of the stuff I do, I say, look, it's the same. Just because it happens online, you apply the same rules as if we were having a cocktail party, right? And so there's no difference that it's online. It's not necessarily true with copyrights because there's only a couple of laws that specifically apply to online behavior. And one's called the Digital Millennium Copyright Act, which is an awesome and powerful tool, Dmca, for content creators. And so if somebody had stolen my blog post and put it online, I can send what's called a DMCA takedown notice. And so I send the DMCA takedown notice, and I could send it to the person who actually stole my blog post, but that guy's, he's going to join you in hell for spreading false news too. So, it may not be very good to send it to him, but I can send it to Google. And I would love to tell you really need to pay a $400-something an hour lawyer to do it, but you don't. So Google, if you just probably Google DMCA takedown notice, Google, there's an automated form. Facebook has automated forms. So you can send it to Google, and obviously if it's not on Google, nobody will see it. They will delist it under the Digital Millennium Copyright Act. And so it's a very easy way to accomplish that. And then if you don't mind, if you're hosting a site, and you are taking in user-generated content, even in blog, right? If you have comments on your blog, you need to take some very basic steps so that you are entitled to these same protections. The purpose of the DMCA is so that websites like YouTube and Facebook and Google they're not liable for this copyright. Because just imagine if every time something was put up that was copyrighted on one of these sites, we wouldn't have them. They wouldn't be able to exist. Lawyers would destroy them, right? Evil lawyers. So they are given immunity for any infringement that's a result of what they call user-generated content. Well, this applies to you too. If you have comments or something on your blog, you just need to go to the U.S. Copyright Office website. They have an online form to fill out what's called a copyright agent. If you do that and you honor a takedown notice, then you won't be held liable for a copyright infringement when somebody in the comments of your blog or whatever you have just totally cut, copies and paste somebody else's stuff.
Oh yeah, that's really great. So along that line too, so you go, let me just kind of recap this to make sure I understand. So you go to the DMCA's website?
Yeah, it's the U.S. Copyright Office.
Okay, the U.S. Copyright Office. And what's there again?
Copyright agent.
A copyright agent. Somebody, I'm hoping, is like taking major notes here.
Just this year they started where you can do it online, where you can register your copyright agent. And truth be told, if this is sort of it's like having insurance. It's sort of if you do check all these boxes, without a doubt, you're not going to be liable. If you don't really have a registered agent, but you honor a takedown notice, somebody says, hey, that's copyrighted material, then nobody's going to sue you, right? Nobody, this is the part about lawyers that everybody hates. We're scum sucking. We go after money. That's all we care about is money, right? I'm not going to sue. I would not advise a client to sue, a blogger who's got 50 followers and no money. To take a lawsuit to trial in Harris County here in Houston is easily $100,000. You can't get to trial if there's depositions and legal fees, and it takes 18 months to get it done. That's hundreds of thousands of dollars easily. If I can't recover money from somebody because they don't have $50,000 just sitting in a bank account, I would tell my client that's the dumbest economic business decision you could ever make. Why do it? There are principle, and my clients often tell me it's a matter of principle, and then they get my first bill, and their principle kind of wavers, starts to waver a little bit. But when we hear it's about principle, yes, my kid, I need private school for my kids. Yes. So I mean, there are reasons to do it, but a lot of times it doesn't make economic sense. And people who might send you a takedown notice or a demand letter know this too. So if you take it down, you may it'll probably just go away. My bad, took it down, and it usually goes away.
Yeah, and that often happens with photos a lot, because photos are often taken from like the internet. People think that they don't have to, that they have no copy. I don't know, that they have no copyright. So could you talk about photos a little bit?
Sure. I would quick show of hands. Who has gotten a Getty Images demand letter? On behalf of our law firm, I can tell you our law firm has gotten one. So I think I saw about 2 or 3 hands go up. Getty's very aggressive, and photographers have a right to protect their images. But yes, people think it's on the internet, I can take it. That is absolutely false, 100% false. And so you can't just cut and paste images, even though
Google search and then look at the images thing and say, oh, that's the best one.
Right. And I hear people, well, it was on Google Images, so surely I can use it. No, you can't. And there's a whole bunch of people went after Google for indexing the images, and there's a fair use issue that they're allowed to use as a defense that wouldn't apply to you if you just copy and pasted an image. But again, 99% of the time, somebody's just going to send you a cease and desist letter, take it down. Getty Images is very aggressive, and photographers use them because they can kind of outsource their enforcement. And we've had clients, a client will call me and say Getty Images is demanding $3,000 because of some image, and Getty Images says that image is licensed out for $50 every 6 months. You've had it up for X amount of years. You owe us $1,500. And the client may have a decent defense. It may be something called use, but $400 something an hour. Within 3 hours, I've spent $1,200.
Pay it.
So again, it doesn't make sense to fight something like that, and so we usually just write Getty Images a check. There's, you can demand to see. You can kind of, the best advice when you get one of these is sort of become a pain in the ass to them, but legally and rightfully say, okay, well, show me the registration. If you say it's registered, show me. You say it's licensed for this amount of dollars, show me where it's been licensed for that amount of money. And if you kind of, or I can just pay you, instead of $1,500, I'll pay you $500. Which one do you want to do, Getty? And Getty will usually kind of come down and say, look, we don't want to mess with this either. We don't want to do all this, and you can get that amount reduced sometimes.
Yeah. So yeah, I mean that's a really good point. And if you are a photographer, it's your stuff that's being stolen. One nice thing about the index is you can search for your own images out there. Can you talk a little bit about what you do if you find somebody with your image?
Yeah, so it's the same way, just kind of that Google Images is a love-hate thing, because it's just as easy to search for people who have taken your image.
You take your image, you drop it in, and then it'll actually go out through the whole internet and look for your image and tell you who has used it, if anyone.
And again, the DMCA is sort of the easiest. It's the poor man's enforcement, Digital Millennium Copyright Act. The takedown notice is the quickest way to do it. And when we do it for clients, we send it to Google. We find out, through a Whois database, which kind of tells you who their host is, what IP firm is hosting the website. We send it to the hosting company. So, HostGator here is in town, is a big website hosting. They're not liable for copyright infringement. Again, imagine if they were liable for copyright violations just because they were hosting websites. But they have an agent on file. They have a process if you go on their website to report infringement, and they'll take it down. So the website itself will also be taken down. The problem is the DMCA applies in America. And so if it's being hosted outside the United States, the DMCA doesn't apply, and there's a lot of jurisdictions that don't give a flip about what we think in America. So it gets a little more complicated when it's international. But in the U.S., the DMCA is a great tool.
Right, and we could talk about that a little bit in a minute about, as far as harassment, and that comes into play when you get to harassment. So speaking of that, let's say that, what about stolen identity online? So somebody takes your picture of you, and I've seen this, that's the reason I'm asking, and then they put it on a Facebook page, and then all of a sudden you are like Tom Jones or something, and then they start pretending like, they're using your image as their image.
All right, so let's stick with the DMCA for a minute on that.
I'm good with that.
So, and this comes up in the context of also revenge porn. Real quickly, boyfriend, girlfriend, everything's lovey-dovey. There's no way this other person will ever do me any harm. Let me take a couple pictures of myself and send it to them. What else could go wrong there? Daughter, if you're listening, daughter, a lot can go wrong. If you're listening, she's 12.
A lot.
We'll have this conversation later, but a lot.
I will actually put this on video and send it to you so you can play it for her and walk out of the room 3 years from now.
So, and we've had these cases at our law firm. The reason I'm bringing this up in this context is on copyright law says whoever took the picture owns the copyright. So if it's a selfie, guess who owns the copyright to that image? The boyfriend or girlfriend, whoever took the picture. And so to get these images down, we use the DMCA to send takedown notices to get these images removed from certain websites. Now, a lot of these websites that troll in these areas aren't necessarily in the U.S., but again, if you can kind of get it de-indexed from Google and some other things, it's certainly, yeah, it's a great tool. But taking it out of that context, let's say you weren't the one, if I took a picture of you, granted you're the focus of the picture, but I took it. So I own technically the copyright. Now, in that context, you can't use the DMCA, but there is an area of law that says I can't misappropriate your likeness for commercial purposes. So if I took Cammie's picture and I put it on the Gray Reef website and attributed some quote to her that said, this law firm is the greatest law firm ever, I love it, she could sue me for using her likeness in a commercial way. Now that's obvious for Michael Jordan. I think it was Kathleen Heigl. She was shot in the street by paparazzi with a certain type of bag. It might have been Coach or something. I don't remember exactly what the brand, but that brand said, oh, yeah, they pulled it and they said, look, I think it was Katherine Heigl. She uses our bag. Well, an endorsement from an actress for a bag is valuable. So they took her likeness without her permission, even though it was a paparazzi that took the picture. She had no copyright to it, and she was able to get them to remove it, but it took lawyers getting involved.
Right, and that's interesting too, because you talk about that. Let's go back to I gave you an endorsement, because I like that. So say I did give you an endorsement. Say I did say those nice things, and you took my picture. Again,
right there.
Yeah. So say I did give you that endorsement, that Travis Crabtree is the best lawyer since all creation. And what would you suggest? And then say later we got in a big fight. And so then I went and had a DMCA and pulled it off your site and did all this stuff because I sent you the picture. It was my picture. I took it, blah, blah, blah. How can you protect yourself against that to begin with? Like whenever you put up something like that, what do you need to do with your clients or the people that are giving you an endorsement? What do you need?
Okay, so let me talk about it from the brand perspective. We've done several endorsement deals for some brands here in town dealing with athletes and other celebrities. So what you're going to see those are obviously going to be heavily lawyered and there's contracts involved. What's going to happen is, one, there's a morals clause, which obviously if the celebrity goes off on a DUI and kills 100 people or,
you can get out of it.
Yeah, you can say, you no longer, you bring harm, you've done something that brings harm to the image of the company. We can get out of our endorsement contract. But what the brands also do is they make the celebrity sign an affidavit that is subject to perjury, technically speaking. And it says, I'm doing this of my own volition. I really believe in this brand. I'm getting paid for this endorsement, but I really believe what I'm saying. And that's to protect the brands from the celebrity going rogue after the contract's, terminated or something happens, the relationship is no longer good. The celebrity can't come back, isn't supposed to come back and say, I just did it for their money. Their product sucks. I don't like it anymore. Well, they've testified an affidavit, again, is subject to perjury, and they promise under oath that they really did like it. So that's kind of what the brands do to try to protect themselves.
And should they be doing that? Should we be doing that when we're working with influencers? Or, I mean, it seems a little bit high-end. What kind of brought me to this was there the guy who's on the Sprint commercial right now. He used to be the Verizon guy. He's like,
can you hear me now?
Yeah, he goes, I know it's, can you hear me now, guy? But, Sprint is like within 5%. So, hey, it's all good. So I'm just like wondering, how did that happen?
There's probably a lawyer.
He messed up.
Yes, there's like those accountants at the Oscars. Somebody probably got fired or is no longer on the Verizon account. So yeah, normally that's taken care of in the contract, and you have exclusivities, and you have sort of like they're called covenants not to compete a lot that says, we're going to hire you for a year.
Not compete.
Yes, not compete. You can't go and you can do other stuff, but you can't go for a competitor in our field. That's pretty typical. With celebrities and online influencers, it's obviously a little bit different. And it gets a little weird with these actors who have, Flo. Just imagine if Flo from Geico. Flo. Frosty. Progressive is probably screaming. If she went to Geico, and the Gecko went to Progressive, there would probably, it just really gets weird as to who owns that character. And there has been litigation that says that character, like Flo, has probably gotten enough where we haven't really talked about trademark, but that character is probably now a trademark of Progressive. And so they would be, if Flo, if she dressed very similarly, they would probably be able to at least make it a pain in the ass again to sue somebody, have enough of a claim to sue if Geico tried to take Flo. I don't know exactly what happened with.
I'm not asking you what's behind the curtain. I just thought it was interesting.
Yeah, it is interesting. It's not 100% clear. It's not it's a slam dunk either way without something in the contract.
Right, and so I would say that with influencers, you probably should have a contract with influencers. We talked about that here. If you're doing influencer kind of relations, that you should have something in it. You're gonna have to be kind of light on the non-compete because they're going to be working for other people too. But certainly, what did you call it? The thing that I liked you clause. What was that?
So it's just a little affidavit that says, and it's pretty. I'm sure if you Google endorsement contract, you'll see the affidavit language. And for an online endorser, it's I would think from the brand's perspective, it would be reasonable to say you're not going to endorse a competitor's product. Again, if they review technology, it's different, right? But if I'm hiring Markiplier or whatever that guy's name is to go talk about my product, and it's not really his core business, he's just a YouTuber, and I could very easily think it would be reasonable if I'm paying him money and I'm a potato chip person. He's not going to do another potato chip endorsement for at least a year after we're done, if not a little bit longer. To me, that would be reasonable from a brand's perspective. Giving it to the review person, you know what you're dealing with from the brand's perspective. They're going to review the Sony television today, and they're going to do the Panasonic. And that would include the $275 flat filing fee. So it's kind of a flat rate. That's all in. Mm-hmm. And I'll explain why you may want a lawyer in a second. But there are services like Trademark Engine, LegalZoom. You've heard, there's a lot of us out there. We charge $69, and for that $69, we have you answer a few basic questions. Hopefully, I've done a good job of making it very plain English and very easy. We take that information, we do your application, we tweak it. We do not practice law. We're not allowed to practice law. We don't give legal advice on the Trademark Engine. But we do fix common mistakes. We tweak it in language that the USPTO likes to see, and we submit it for you. So then we collect the $275 from the customer as well. So for about $350-ish, we can take care of it for you if you don't want to do it yourself. So it's, in the grand scheme of things, it's not that expensive. For $350, if you wanted to use a service, or $275 on your own, you can get a trademark and make sure you have that national protection.
That's great. So
the real quick on why you would need a lawyer would be and what I often tell people when they're using the law firm is look, before you hire us, do a Google search. There were 12 Zoeticas out there in the world based on a Google search. Then you may want a lawyer, because there are artful ways and creative ways of filing your application and talking to the client about, what makes sense. Do you really want to spend the $375 to do this? So there are creative ways that a lawyer can come in handy in filing your application if you think it's going to be close. Or one issue on trademarks is if it's generic. If you had Houston Marketing Agency, you're not going to get a trademark. That's obvious. But there's close ones. Let's say, I don't know, penultimate, or somebody comes up with, wow, this is a great word that means the best, marketing agency. That probably too is going to run into problems. But if you really want to trademark and really want to use that, you should have a lawyer probably do it, and they will help you increase your chances of getting it through. Like on our website, it's pretty much automated. I'm the only lawyer that works there. I don't review. We get 70 applications process a day. I don't review them unless there's an issue, or one of our processors asks me a specific question. So you're not getting that type of legal advice. So you may need that depending on what you're trying to do.
Now, with the trademark, does it also matter? If I changed my logo, what would that do?
So a name and logo are two separate filings. I'm smiling. We have a chat. We have an online chat on Trademark Engine, and that's one of our pre-done things where we push a button and it answers that question. That's why I'm smiling. Sorry.
So many people. So we needed to do that here.
So it's two separate filings. So you have a trademark in your name, you can have a trademark in your logo. And obviously people who are looking online and wanting to pay $69, multiplying that $275 times 2, that's a big deal to make it $550 all of a sudden in filing fees. But you can do both. You can get a trademark in your logo. That protects your logo just in that style. And if it's something close to it, you can probably keep somebody, Starbucks. You may have read like Starbucks has gone after Starbuck, and people I'm not even sure how much they use the image of the woman that much anymore.
Right.
That shadowy thing.
Right.
That protects that logo. But if you change your logo and completely rebrand to something different, then whatever you've invested is now gone. Because on trademark law, if you quit using it, you abandon it, and whatever rights you had are gone. So we usually advise people, when you're on a budget, start with your name first, because you're less likely to change your name. Mm-hmm. But if you have the budget for it and you really are happy with the logo, trademark the logo too. And what that protects is anything that is similar enough that it would cause the term of consumer confusion. The consumers would look at your logo versus this other logo and think that they might be the same. So it gives you protection. It doesn't have to be an exact copy of your logo. If it's close enough and people get confused, then you would be able to sue over that.
Yeah, one of the ones that was local that kind of not just logos but also name was Mission Burrito, that had to change to Burrito now. So with Mission, the other one, my kids actually got really interested in that one.
Yeah, it was so Mission. There's a Mission company based here in Houston that does. You can buy tacos, shells, and tortillas at the grocery store. Right, so they do. It's probably 30 staple goods, whereas Mission Burrito was restaurant services under Trademark. But they had a big fight, and it was in the newspaper a lot, about whether people were confused and thought that Mission Burrito, the restaurant, was somehow affiliated with Mission, the tortilla makers.
Company. Yeah. They won.
I think it was through it was through a settlement. I don't think it actually went to trial. And again, a lawsuit like that is easily going to cost $400,000 or $500,000. I know that sounds
and
crazy.
More than that, because they had to rebrand all the Mission Burrito restaurant locations to Burrito.
Right, and so, but my point is that's probably what led to the settlement. Mission Burrito, the restaurant, was looking at, okay, we're going to spend $400,000 or $500,000 defending this, and these are conversations lawyers have all the time with clients about, does this make sense? You're going to spend $400,000 or $500,000. It's maybe 50-50, or you can decide to bite the bullet and rebrand and be done with this and have certainty. Which business person do you want to do?
Yeah.
I'll help you either way, but whatever one you want to do.
Yeah, so that's awesome. Thank you. So that's Trademark. I want to actually open this up to questions really quickly, because I'm sure that some of you might have some. So let's just do that. Whoop, 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 whoop. Let's start with you, Karen, because I saw you first. Online contest. Yes, actually, it's on my list, so let's do that. That's another one here.
Sure. Yes, we deal with that a lot. So the online contests, and I'll try to do it briefly. The key issue is to make sure you don't have a lottery. All right, lotteries are illegal. We cannot do lotteries. Only governmental entities can do lotteries. So what does that really mean? That means you can't have a promotion that requires the customers to give what's called consideration. Consideration is a fancy legal term for anything of value. You can't make the customer give you something of value in order to participate in your, what is essentially a sweepstakes, what should be a sweepstakes. So that's why when you see a big contest out there or sweepstakes, you'll always hear the fine, the real quick one. What they're saying is, in order to enter this contest or sweepstakes, send a self-addressed envelope to this address. That's the legal term for that is an alternative method of entry. AMO. Lawyers are really creative, right? So we call it the AMO. If you're going to have a sweepstakes, you should really have what's called the AMO, because that is sort of the insurance policy that if you have that, there's no question that it's not a lottery. So an example of what would be a problem, if I said, in order to, we're going to give away this computer, in order to be entered into the drawing for this computer, you've got to buy a dinner here tonight, right? How is that different from I'm going to pay $1 for my lottery ticket to enter the chance to win a lottery? It's not different. Yes.
Submit a recipe. Oh.
Okay, so
restate the question.
Yeah, so the question is, and that's kind of where I was heading. What is consideration, right? And where's that line? There is no bright line test, because her question was, what if in order to participate and win the computer, you have to submit a recipe? And so there hasn't been a lot of litigation. And the reason I said a lawsuit about this, lawyers would prefer that there was, because that would mean there's decisions from a judge that tells us what the rules are. So it's mainly been a lot of academic type discussions about what this is. So my example of having to buy dinner clearly without an alternative method of entry, this restaurant could do it and say, yeah, you can also enter by sending in something in writing. That solves their problem. So what is that level? And the academics and even the Federal Trade Commission has said requiring a like, requiring an email address, minimal types of things like that are not enough to bring it up to the level of a lottery. Submitting a recipe is probably the same thing, and I don't know, if it was done by. And
I guess the recipe, she's talking about intellectual property issues around that. But
yeah, so now I would tell you, so that's again one of these grayscales. If I said you had to submit a recipe, you had to bake it, you had to shoot a video of yourself making it, and you had to bring it up to the office so we could taste it. Now you've gone from it's not that burdensome to that's pretty darn burdensome. And I would guess if it's somebody like Sarah Lee or Betty Crocker that's doing it, their lawyers may have put in the fine print, you can also enter by sending the self-addressed stamped envelope. So let me do so that's why how much insurance do you want to be? How much
they have an ammo.
a pain in the ass is your lawyer, right? And do you want to listen to your lawyers? Recipes is a unique intellectual property thing. You cannot have a copyright to a recipe. A recipe is an idea. It's just instructions. So there is no copyright to just a recipe that lists ingredients and says, next bake this, preheat your oven, do this. And that's been litigated. That's where we have certainty, because it's an idea. Cookbooks and things like that are copyrightable because of the way you lay it out, and they have the introductory paragraph and the image that goes with it. So like cookbooks are entitled to protection. But simply that recipe, the Houston Chronicle does, I think it's still Wednesdays where they do the savor section or the food section. I could copy those recipes in there and put them up on my blog, and ethically I would attribute them, but legally they're not entitled to protection.
So I have a friend who does a lot of.
I have a friend.
He has a friend.
I'm sure you do. I'm sorry. Go ahead.
images of the convention center, you put it into an email and say, hey, we're going to be at this convention center at such and such a time. So because it's being emailed and you can't take it down, what happens if they have a problem with it, even though why would they? Because we're promoting them. The second part of the question is, like with trade show logos, where they say, do not alter the logo. But I mean, how do you not put your booth number at the bottom of the logo, which kind of alters it, and then you email that out? So if somebody had a real problem with that, and you emailed it out, there's no way for you to take it down. How much trouble are you
So we're talking about email now, which is a little bit different than being online. But the question was, if you're going to a destination or to a convention center, can you use the photos of the convention center and destination in the email to show people where they're going? And in the case of altering logos, adding a little something at the bottom of the logo, what kind of trouble are you in?
Okay, so
Are you going to hell?
No,
Okay, good.
no.
I've got some ideas on that one.
Yeah, I was about to go political. I'll be nice.
No.
So
Then you'll go to hell.
right, exactly.
All right.
So let me try the first one. On the using the images of the convention, the GRB or George R. Brown here in Houston, a lot of companies and hotels and things like that, they're perfectly happy. Now, technically, could they sue you for a copyright infringement or send a demand letter? Yes, they could. But they're not going to, and they may even have some language on there that talks about a Creative Commons license.
They also probably have, if you just call them, they probably have a whole bunch of images that they have exactly for that purpose, just so you know. Because I work with destinations, and we always have like a whole bucket of photos that we're willing to give people to use. But anyway.
Yeah, so in that situation, I would just, do I need a contract for this? I'm like, yeah, I'd love to make more money and draw up a really nasty contract, but just save the email where they said, yeah, use these images when you talk about our thing. Just save that so you have it if it ever comes up. And so most of the time you're not going to have an issue there. When they say don't change the logo, and so we get this on our website, we do logos as well, and people will, if I wanted to do a logo of Zoetica, the way she's got typeface, the font and all that, I have people that shoot me a phone. They'll use their phone and shoot me the image, and I have to tell them, no, I really need a clean, professional image, because if I file that with the trademark office, your officially protected logo will have a big red bar and the word sponsored by as part of your officially registered logo. And I'm telling you this because, putting something underneath the logo, it won't violate that. Don't distract it. I mean, unless they have, I haven't really seen it, but I know some people are very particular about it, and they say don't put anything within a certain amount of pixels.
Space. Yeah, they usually, but they may have some rules, but I don't think they're going to sue you for that necessarily.
Right, and a lot of it is just, I'm sorry, mea culpa, we'll get you out of
I think the big problem would be if you took that logo and you put it somewhere like on your business page as your like profile picture.
Right. Or put your booth number like across the logo, right? That's clearly in violation. But having your logo right beneath it, shouldn't be a problem.
And you shouldn't also express any endorsement, like that they're endorsing you. Do you know what I'm saying? It shouldn't be like that they're endorsing your booth. Like, oh look, the trade show says you should all come to our booth. So I don't know. Yes, in the back.
So I think that like as a freelance, people might carry my own insurance to protect myself. But what about like, if I'm going to start taking on a client discount, is there a certain contract that I could have with Money Club that would protect like, look, I'm not going to put your business in harm's way intentionally and you're not going to sue me for trying to do business with you and what you want done. Is there a certain contract or something that I could tell them to draft up for me that would just be like a sign line?
Yeah, so the question was, as a freelancer, what type of contract might I need if I'm working with a company? And I'll kind of answer this question both on behalf of the company and maybe the marketing firm. Yes, you should have a contract. Here's the number one mistake from the brand's perspective is we've now talked about copyright law. If you take the picture, whoever takes the picture owns the copyright. If I was the freelancer and I write copy, I own that copyright. That's my intellectual property. So from the brand's perspective, you need to have a written contract, and it really needs to state that this is a work for hire. This is one of the few times that there's quote unquote magic language. So work for hire, drill that across your head if you're representing brands and having people create content for you. Without that language, the freelancer owns that copyright, and there could be a fight down the road, and the freelancer says, take that copy down. That's my copyright. It really runs into it more with web developers and software developers, because people hire their nephew or hire somebody's friend of a friend to do the software. Well, whoever sat down and coded that software, even though I may have told him or her, I want these 6 things, I want this to go here, they're the ones that sat down and did it. They own the copyright. So that's the number one important thing, is the work for hire language. And even as a freelancer, you want to be professional and clarity and say, and from the freelancer or the marketing firm's perspective, I make it clear that you don't own it, brand, until you pay me. And so that ownership doesn't kick in until this contract is 100% fulfilled and I have been paid in full for my work. So that's one aspect. And I'll go over really quickly a couple of other things is from the freelancer marketing agency perspective, I usually have language in there. There's lawyers like to say warranties and representations. So the company that is hiring me is going to warrant and represent what they're giving me and telling me to put up on a website or content to create is lawful, is legal, it doesn't violate laws and regulations. It's very hard unless you kind of specialize in a field to know what some of these rules are if you're working with hospitals, banks, stockbrokers, lawyers. So you've got to rely on that company, because you as the marketer who's creating this stuff could be liable. So we make the company say, I promise the stuff I give you will be lawful and won't violate any intellectual property, third-party rights, or any regulations. And there's something called indemnity, which a lot of companies will fight back on this, but I also say you should start off anyway saying, company, you're going to indemnify me, the marketer, if I get sued because of something you gave me that I didn't know was against the
Well,
law.
I have clients that make me do that too. So I have to indemnify them in the actual insurance policy too.
Right. And so to flip that from the company's perspective, I always advise, I want a warranty and representation from the marketer that's going to say, one, you're not going to violate somebody's third-party rights. You're not going to cut and paste. If you cut and paste, I'm going to get sued, and I shouldn't be getting sued because you were lazy and you cut and paste something. So I have that warranty come from the marketing person go that way, and also say it's not going to be unlawful. You're not going to defame somebody. You're not going to commit certain torts or certain violations. If you do, you're going to defend me. And so those kind of go both ways, but those are some of the kind of contractual terms you have in there. And just from a logistical standpoint, you should start with a general terms and conditions. Like this applies to every deal, and I don't know how you do it, and then there's an exhibit A. A lot of times it's called a statement of work, and that's where you have the particulars. I will create X amount of materials for this amount of dollars. So all you're ever changing is that statement of work or that exhibit A, but you have your boilerplate warranties and representations and your work for hire language and your indemnity language.
And that work for hire can go a little bit far from the consultant side. I can say sometimes they'll say anything that you create while you're in our sphere, we own it. So like, especially if you're also an employee, that can happen. They'll say anything you create off hours is ours. Anything you create. So I mean, do look for those kinds of languages and push back against them a little bit.
Yeah, especially real quick, if you're doing some coding, there's some kind of software coding in the there's always tension, and as a lawyer that represents both sides, I obviously recognize it and try to explain it to both sides. If I'm hiring you to code something, I want that should be mine, right? You shouldn't be able to sell that to somebody else. Well, as a coder, the reason company you can afford me at my rates is because I use the same building blocks, and these are well developed, and these are best practices. These building blocks apply to everything, and I may be willing from the software developer side, I may be willing to say, you own it and I won't do something in this industry using this thing. But I sure as heck have the right, just because I built you some type of form generator thing, I can build a form generator for somebody else. You shouldn't have the exclusive to that. But some of those, if it's a very strict, we'll say, you can't build, whatever you build for me is mine and you can't build it for anybody else. Well, what if you're building a form generator, right? So you've just got to read those, and there is a tension. And usually when people just talk about it and explain it to each other, you kind of come to that agreement.
People talking and explaining and not yelling at each other and defriending each other. Yes.
You said we weren't going to get political.
Sorry.
So say that you apply for a CRA marketing on behalf of the client, submit something that has content where they click on images, original content, and then in turn it's posted on our site. Where does the liability fall on that?
So he asked about press. He says a press release distribution. What if you get content from somebody and photos from somebody, and then you put them on your site, and who's in charge of knowing if that was taken care of or not?
So one answer is that I would make the argument if I were representing you and you took somebody's PR release and you more or less copy and pasted it, that's user generated content, and under the DMCA, if it's online, then I would argue I was immune from that. Now, if you tweaked it so that the term of art is who is the publisher of that content. If you tweak it enough, you can become the publisher of that content, and you no longer have this immunity that the DMCA gives you. And so, but I do want to clarify kind of a myth that's wrong out there. And that myth is some people think that if I remove certain comments, if I have a message board or comments to my blog or the Chronicle type of thing, if you remove posts, you still have this DMCA protection. Just because you exercise some editorial discretion and remove things, you still have this immunity. Now, if you take somebody's comment and you tweak it enough so that it's no longer really their comment and you've edited it and it's kind of become yours, you've lost that. You are now the publisher and therefore liable. But I did want to kind of dispel, I don't know if that answered your question, but I kind of wanted to dispel that myth that came to me.
Probably since you guys just passed them on as is, you're good. Yeah. Yeah. You've been sitting there.
Yeah. What about if you say you take like a tweet and embed it to the website?
Bed.
Someone, if it's the article, but you get credit to that.
Embedding tweets, because there's this whole embed policy. I mean, you can embed Facebook posts, you can embed tweets.
Yeah, I think
Do that. So
I think I have that on my blog right now where I've embedded a tweet.
do it all the time.
So again, that's one of those. It's probably the worst case. What's the worst case scenario, right? Is somebody really going to sue you over that? Likely not. And I would have to. I haven't in a while. I would have to read Twitter's terms and conditions. Like, I know y'all read those all the time, right? Yeah, you got to remember. So, on Twitter and Facebook, last time I looked at them, it's usually that it is not a violation to repurpose the stuff, repost it on the platform, right? So retweeting and reposting and sharing on Facebook is when the content creator puts it on these platforms, they give permission for retweets and sharing online. The last time I looked, it didn't say that you could take it off of Facebook or off of Twitter and put it somewhere else. So technically, whoever posted that tweet, even the 140 characters, they have the right to those 140 characters. But it's one of those things, and it can be a fair use, like Donald Trump tweets. I promise I won't get political, right? But Donald Trump tweets. His tweets are newsworthy because he's the president. And so that's a fair use, right? And you can use it. So if there's something that's in the news or that's social commentary that's, or even people responding to Trump is probably going to be safe under a fair use doctrine. So you're not likely going to be in trouble. So I would say go ahead and use it. Now, if you took Kim Kardashian's tweet and kind of put it right next to your product, so it made it look like she was endorsing or sponsoring.
Endorsement, I think, is the issue here.
Yeah, that's
right?
where I would say don't do that.
And that's actually, I'm going to come to you because I saw your hand up, but just while we're on endorsement real quick, that's becoming a huge piece of this, right? So how do we talk about when we're endorsing something, and do we have to talk about it? I mean, as a brand. So like, for example, I've been seeing this a lot. To make things more viral, a site you'll purchase something and they'll say, share this with your friends. and they'll give you the share button, and you click on the share button, and it automatically will help you share it to like Facebook, Twitter, wherever, and it will give you some sort of credit on the backside. Like, so it'll say, yeah, you know, you get $10 if you, or $5 or a coupon or whatever if one of your friends signs up for this. But it doesn't, like, you didn't sign a contract. You don't feel like you're really you don't feel like you're endorsing them, but you're endorsing them. So I mean, I disclose, but my question is, how's that going to work out?
All right, so let's start big picture first. So the Federal Trade Commission came out with some online endorsement guidelines. So, and to the Federal Trade Commission's credit, they have fairly well-written, plain English guides that are fairly helpful. So if you have questions about online endorsements, if you just FTC online endorsement guide, they have a guide and FAQs that are pretty good. But their rule is if you're endorsing online, it has to be disclosed in some way and make clear that it's an endorsement. Their opinion is when you see Michael Jordan doing a Hanes commercial on TV, you know Michael Jordan's getting paid for that. When you see Michael Jordan go to Twitter and say Travis Crabtree is the best lawyer in the history of the world, you don't know if he.
Then you know Travis is getting paid for that. I'm just kidding.
So you don't. The FTC says it's not clear whether he really just got done with an awesome consultation and felt that way and tweeted about it, or if he's getting paid for that. And so they have said when it's online, it has to be, if Michael Jordan were getting paid for that, he would have to do like hashtag paid or hashtag sponsored or spawn, or there's little really short things that you can put on Twitter to do that. So that's sort of the big picture. So how does this all fit into a lot of the topics we're talking about? The best example I can bring is the Cole Haan. I forgot exactly the name of the contest, but Cole Haan ran a contest. It was really a sweepstakes. In order to enter into the sweepstakes, you had to take an image of you holding your shoes somewhere in the world. That was your entry into the sweepstakes. And then they were going to take, randomly draw a winner out of that. So the Federal Trade Commission said that Cole Haan should have made it clear that this was a sweepstakes and contest and required all valid entries to have some type of hashtag. This was on Pinterest, so I don't do Pinterest. So whatever Pinterest equivalent to a hashtag would be, that this is, hashtag Cole Haan sweepstakes, right? And the Federal Trade Commission's position was, I'm a viewer at home. All my friends are suddenly pinning all this great stuff about Cole Haan. Do they really, do my friends really into Cole Haan? Or are they doing this because of a sweepstakes? And without some type of designation, they don't know. And so this was the first time the Federal Trade Commission kind of made these rules. So they said, Cole Haan next time, right? And everybody's on notice that when you do a online contest or sweepstakes like this and you require somebody to submit content, you have to make it clear it is part of a sweepstakes or contest. So that's the sort of again, being the evil lawyer that the marketing people hate, is like, yes, we really do want you to put hashtag contest.
Cole sweep or something like that.
Yeah. So that's kind of the best example that kind of talks about a lot of these issues.
No, that was great. So I'm going to get you because you can.
Yeah, so you really only need the ammo so that people can enter the contest without having to pay for something or do something of value enough that it's burdensome. And although there's not a ruling from the Federal Trade Commission yet, most people believe that simply liking, posting is not going to be enough where they say, well, you're really making the people that enter the sweepstakes have to give you something of tremendous value. So they're going to say that's okay. You're not going to need an ammo in this.
As long as it meets the terms and conditions of that platform too. So you have to watch that too, because those change all the time. Yeah, he's actually, Andrew, if you don't mind helping, one of the interesting things that Travis was so nice to bring for us is an online promotions checklist that all of you guys can use in your, it's for free. So thank you, because it's like a pretty valuable thing. So Andrew's passing it out to everyone.
Yeah, real quick to kind of wrap up the online, more questions is fine, but The other thing that is a trap is if you give a prize away for more than $500, the state of Rhode Island makes you register. And so what I often tell people is
keep it under $500.
Keep it under $500. You don't have to register anyway. In Florida and New York are the other two states, but their thresholds are higher. I don't remember if it's 1,000 or 1,000 or 5,000 or 1,000.
So that's if you're doing an online competition anywhere in the United States because it's national automatically because you're online. Is that
Yes,
true?
That would be true. So,
Okay.
And so what we recommend is either keep it under $500 or limit it to, if Canopy was doing a concept, they don't need to make it eligible for Rhode Island residents, right? Why would Canopy do that? So I would advise this restaurant, if they were to do an online promotion, a sweepstakes, residents of Rhode Island are not eligible. And that way I would probably tell them to do New York and
Florida.
Even Florida, if they were doing, free dinner for a year. Right?
Or a cruise or something.
Right. And so that's just be cognizant of that. If you get over $500, you might be, and it's on the checklist that talks about that too.
So I'm going to go over here because, yeah. Photo releases. Very good. So yeah, capturing photos of people in the public. I know there's a rule that lets you do that, but they may punch you in the face. But anyway, go ahead.
Right. So if I'm at Discovery Green enjoying a concert or something or a movie night, and somebody takes my picture, even if it's Discovery Green and they're going to use it for commercial purposes to promote it, they have a right to do it. Now, if I was Beyonce, I'm just trying to think of a local celebrity, right? If Beyonce is there, she has her rights to her images and her likeness are valuable. So she may have the ability to say, no, I'm not letting you use that image. If it was, if she was there, that would be newsworthy. So the Chronicle or the Houston Press or whatever, these glossy magazines and stuff like that, they would be able to use that for the news purpose. But if Discovery Green wanted to have it on their website for marketing, it gets a little gray. My image and likeness is not valuable, so they could use it. The best practice if you're hosting an event would be to have it when they sign up that, hey, you authorize us to take your picture at the event and use it for commercial purposes.
If you come to the Social Media Breakfast of Houston, you will be online. You will have your photo taken, so please don't come if you don't want to. There is a live stream. You don't have to have your photo taken. So yeah, no, that's really interesting. And what about if somebody takes that picture, uses it for commercial purposes and like this? Oh, look, watch out for predators and in the park. And they use it as like, they can look like normal people. And here.
So in my old TV days.
Sorry, but it is true.
No, we did. I mean, think of the TV news, right? And we did a story on obesity. And so you've seen all the images that the newspaper,
the people of Walmart,
right? They will, the professional journalists will use, only shots from here down. They're going to make them blurry, just so people don't get offended. And there's not really legal liability that comes along with that. It's more of a best practice. Now, if it was, be careful if I'm at the park with my son, right? I just happen to have my arm around my son. Who's 10, and they use that image to say, be careful of sexual predators in parks. They're going to get, even if it was used, they took that picture in Bel Air, right? But they used it in Philadelphia or something, and they just thought that was a stock image they had the right to use. I'm going to send them a letter to say, take it down. And if they refuse to do it, I would probably sue them because that gets into defamation. And it doesn't have to be expressly said that Travis Crabtree is a child molester, but insinuating so that people would look at that image and come to that assumption is enough to make you liable. Perfect. So it's a good idea if it's a good idea not to use those images, but if you do, have it through a Creative Commons, have it through somebody who's willing to be a stock photo for that purpose, and have them sign off on it.
Yeah, and even if you get something from like Deposit Photos or Creative Commons, I would be really careful if you're using an image in that way to either blur the features or do something that protects you
I
and
mean,
them.
on those stock photos they have where it's like the shadow of people, so it's not real, like a playground, empty swing, playgrounds with the shadow of a big hulking dude, and all you see is the shadow. So
Yeah.
do those.
So there was people over here. Yeah, Jackie.
I wanted to ask about using endorsing, but for a public service, for example, mass transit. And we take the comments that people are, using, we tweak them on a different software, republish them on Facebook or Twitter. Is there a gray area there?
So you're taking things that, okay, so the question is taking comments that people make about your brand on social media and then pulling them off and putting them on another photo or something?
Yeah.
Like making it into something new, and then reposting it on the site. What's your thoughts?
So my initial reaction would be, if I were advising you, my preference would be that's okay, but change it from Travis Crabtree to Travis C. period, right? So that it's not clear. If people do that with websites, right? They get endorsements or they get reviews, and they take those reviews and they put them prominently on their website. And so my advice again would be to say Travis C. Houston, Texas, right?
Or get permission.
Or obviously, if you can reach out to that person, that would be the best. And I would love to tell you again, pay a lawyer a whole bunch of money to draft that contract, but just shoot the review person an email. Say, hey, thank you so much for this. There's probably, she will tell you, or the other marketing people will tell you to do the goodwill thing. But hey, would you mind if we used it in this way on our website? And if they say yes, print that email, put it in a file or scan it.
Yes. And then you protect, because people love it actually. And talking to them is the best way also to build the relationship. So I always recommend, we do it all the time downtown Galveston. We reach out to people and ask them if we can use their words and their images, and they love it. Cross post them to Facebook, and then we'll tag them, and they know that way. Yeah, Sarah.
So I had a question about owned hashtags. Seems like there's a trend now.
Owned
To,
hashtags.
like for the Olympics, that you can only use the Olympics or Super Bowl hashtags if you're a real sponsor. It seems to me that hashtags are part of the public domain, and to take ownership of them seems odd to me. So just wondering.
So can hashtags be trademarked? That's another question too.
Because it seems like they're trying to do that.
Well,
Or limit the use.
right. And so the Super Bowl is the best. We just have the Super Bowl here, right? And hopefully none of you use the Super Bowl without their permission. If you did, you probably got a nasty letter. Because they enforced it in a nice way.
Some of the people in this room were working the social media for.
As is their right. You're right. They protect that.
Yes.
They protect that mark. And
Letting you know.
the trademark to Super Bowl applies in all contexts, right? It doesn't matter that you simply put a number sign in front of the word Super Bowl. You're not authorized to use Super Bowl unless you're an official sponsor. Hashtag big game. I don't know if they probably would.
Yeah, they were good with that.
And I know that y'all put up here's what you can do.
Mm-hmm.
And so hashtag big game would be fine. But as soon as you do Super Bowl, they have a right to control the use of that mark, even in the hashtag context.
Yeah.
So what is it? Sorry.
Well, you're going to hell too. I'm just kidding. Sorry, Sarah.
You're going to hell. You're good. You're all going to hell.
You're fired. I'm sorry. We're getting political again. Well, what was the follow up? Okay, Lewis. You use their phone, but you take their picture. So if I took your phone,
it's still the photographer, right? The person that took it, and I promise I'll be brief. So the
No.
most interesting case that came in, y'all may remember the Monkey Selfie. So the Monkey Selfie case, the monkey took a picture of
monkey business
of himself, and it was a really cool picture. And so the artist and everybody shared it. Look at this monkey taking a selfie. There was he was a photographer, and his theory was, I'm the one that spent time with these monkeys. I set everything up so that this could happen, even though I didn't push the button to take the picture. Because I did all the work to make it happen, I own the copyright to that image, and he lost.
The monkey owned the copyright.
Yeah, and well, really, it's a question of who really, if anybody, owns the copyright. But because he didn't push the button, he wasn't given the copyright.
Anybody could use it then at that point. It became free, fair use. I am going to have to quit, guys, because it's really we're literally going all the way to 10. So all those questions that you were totally right. You said there'd be a lot of questions, and there were. Will you stay for just a few minutes?
Yeah, I'll be happy to stick around for a while. So
I want to just say thank you so much, Travis, for coming and talking to us today. Could you give him a huge hand?